3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files.
Yeah.
Last time we walked through Julie K. Brown and tested what the records could actually prove without speculation. Today we are examining July 6, 2019 and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is the FBI NYPD Joint Task Force Arrest Report from July 6, 2019, documenting Epstein's takedown at Teterboro Airport in New Jersey after he returned from Paris on a private jet.
And that document, that arrest report, is really just the endpoint of a different record we need to start with.
Which is the Flight Manifest.
The Flight Manifest, specifically the Customs and Border Protection records of border crossing. That's file EFTA 00030308049.pdf.
Because before you can have an arrest, you need the subject in your jurisdiction.
You do, and this document is the moment that happens. It's the anchor for everything that follows on that day. It shows the aircraft, a Gulfstream G550, tail number N908JE, crossing an international border.
Originating from Paris Le Bourget.
Right. And landing at Teterboro Airport, TB, in New Jersey. That choice of airport is significant in itself.
It's not JFK. It's not Newark. This is the primary airport for private aviation into New York City.
It is. It's designed for a certain kind of traveler. The entire infrastructure is built around discretion and speed. You step off your jet, onto the tarmac, and directly into a waiting car.
Minimal public interaction. No crowded terminal.
Almost none. So for federal agents to be waiting there, on the tarmac itself, it signals this is not a routine customs check.
The CBP manifest gives us the exact date and a time window, July 6, 2019, a Saturday. The arrival is logged around 3:00 p.m. Eastern Time.
And it lists the sole passenger of note, Jeffrey Edward Epstein.
And his name on that manifest is the legal trigger.
It's the tripwire. The second the wheels of that jet touch down in New Jersey, he is on U.S. soil and subject to domestic law enforcement. Any legal complexities of arresting him in France or, in international airspace, they just evaporate.
Which brings us back to the arrest report itself, the arrest form PC Epstein.
Right. This form documents the action taken the moment that jurisdictional trigger was pulled. It confirms the custody was immediate.
This wasn't a summons. It wasn't a request to appear in court on Monday morning.
No. This was a physical takedown on the tarmac. The document specifies the arresting agency.
The FBI NYPD Joint Task Force.
And not just any task force, the Crimes Against Children Unit. That's a very specific detail that tells you how this case was being framed from the very first moment.
The charge listed on that intake form is also specific.
Extremely. Sex trafficking of minors and conspiracy to commit sex trafficking. And it references the sealed indictment that enabled the whole operation.
Southern District of New York Indictment, 19 CR 490.
That's the case number, 19 CR 490. You see it repeated on every single document from this point forward. It signifies the formal public opening of the federal case in New York.
A case that had been, for all intents and purposes, dormant or at least contained in Florida for over a decade.
It represents the unsealing. The arrest form is the operational receipt, you could say, for that legal shift from a closed case to a very, very active one.
We also have internal government communications that confirm this.
We do. We have emails from the Pinpoint database, specifically document EFTA 000021275.pdf. This is an email sent at 6:36 p.m. on July 6th.
So about 3 hours after he lands.
Correct. The information is moving up the chain of command. The subject line is unambiguous.
Epstein is in custody after flying into Teterboro, NJ today.
And you have to look at who this email is going to. It's routed to the Justice Management Division, JMD.
This is internal DOJ notification.
It is. It's the bureaucracy of a major arrest. And the tone, it's worth noting, is completely procedural. It's dry.
There's no surprise here. No sense of a chaotic event.
Not at all. It reads like a system update. Task completed. It confirms the fact of custody, the location of the arrest, and it establishes that the Teterboro operation went exactly as planned. This is a pre-planned, coordinated federal action.
Okay, so he's in FBI custody on the tarmac. What happens next? The FBI doesn't run the jails?
No, they don't. That's the job of the U.S. Marshal Service. And we have the records for that transfer, the USM-129 Individual Custody Detention Report.
This document is essentially the chain of custody for a human being.
That's a good way to put it. It tracks the body. It shows the moment he is formally handed over from the arresting agents to the federal marshals who will be responsible for his detention.
And the paperwork generated during this intake is critical.
It dictates his entire experience from this point on. On those forms, there are check boxes. They're not just administrative fluff. We see the box for sex offense is checked.
Which is expected, given the charge.
Of course. But more importantly, we see the initial indicators for flight risk being assessed and checked right there at intake.
And that single checkmark sets a path.
It does. It starts the documented justification for holding him in the most secure conditions. It influences housing arrangements, transport protocols, everything. That checkmark on July 6th is the beginning of the paper trail that ends with him in a specific cell at the Metropolitan Correctional Center, or MCC.
Now, we have to address the major gap in the record here. The documents tell us how he was arrested. They tell us where. They tell us what the charges were.
But they don't tell us why he got on that plane in Paris in the first place.
Exactly. Why return to the U.S. if a federal indictment is waiting for you?
And the public record does not answer that question. We can see from the CBP manifest that he flew back. We know from the indictment that it was sealed, so he may not have known about it explicitly.
But his lawyers were likely in communication with prosecutors. He must have known something was coming.
One would assume. But we don't have a document, an email or a signal intercept that captures his motivation. We don't have a record of him saying, I'm coming back to face the charges, or I'm coming back because I think this is manageable.
So we have to stick to what the record proves.
We have to. And what it proves is the movement and the interception of that movement. We can infer that he didn't expect to be arrested on the tarmac. Filing a flight plan to a major U.S. airport is not typical behavior for a fugitive.
It suggests he believed he could land, deal with whatever was coming, and not be immediately taken into custody.
That's a reasonable inference, but it is an inference. The hard fact, the documented fact, is that he landed and the federal government was waiting for him.
And the action wasn't confined to New Jersey.
Not at all. The Teterboro arrest was just one half of a pincer movement. While that was happening, a second federal team was moving on his residence in Manhattan.
This takes us to the search warrants, evidence block 2.
Correct. For this, we turn to the U.S. v. Jeffrey Epstein bail memo. It's document number 14 in the court filings. This memo was written by the prosecutors just days after the arrest, and its purpose was to argue against granting him bail.
And to do that, they had to detail what they found.
They had to lay out their evidence. And the memo confirms that simultaneous to the Teterboro arrest, a search warrant was executed at his townhouse at 9 East 71st Street.
One of the largest private homes in Manhattan.
A mansion. And the timing here is absolutely critical. It has to be synchronized.
You can't let the news of the arrest leak out.
If it does, anyone in that house staff, associates, anyone has a window of opportunity to start destroying things. Shredding documents, wiping hard drives, flushing things. The only way to prevent that is to hit both locations at the exact same time.
Which the documents show they did.
The bail memo confirms it. The scope of the warrant was broad. It authorized a search for any evidence related to the charges, electronic devices, financial records, and, crucially, the contents of any safes.
And they found a safe.
They did. And in a forensic search of this nature, a locked safe is an immediate priority. It's a container designed specifically to protect high-value items.
The agents gained access to it, and the bail memo provides an inventory of what was inside.
It does. It lists 3 categories of items. First, loose diamonds.
Unappraised at the time of the initial report, but clearly of significant value.
Second, the memo says massive amounts of United States currency, cash.
Again, this speaks to the liquidity. Assets held outside of the formal banking system.
From a prosecutor's perspective, this is what you'd call a go bag. If you need to flee the country, you can't exactly wire transfer your bail money. You take things that are universally valuable and untraceable. Cash and diamonds fit that description perfectly.
So the diamonds and the cash build a picture of someone with the means to disappear.
A very strong picture. But they are secondary. They're supporting evidence compared to the third item they found in that safe.
The passport.
The passport. And not his own U.S. passport. They found a foreign passport.
Specifically, an Austrian passport.
And an Austrian passport. But the photo in the passport was a picture of Jeffrey Epstein. And the name on the passport was not his name. It was an alias.
The memo also notes the residence listed on this fake Austrian passport.
It does. The address listed was in Saudi Arabia.
Let's pause on that. An Austrian passport with his photo under a false name listing a residence in Saudi Arabia, found in a locked safe next to a pile of cash and loose diamonds.
That is the collection of facts presented to the judge. Think about the signal that sends. It's not just about wealth anymore. This is documentary evidence of a prepared escape route, an established alternate identity.
And a destination in a country with no extradition treaty with the United States for these types of crimes.
Precisely. That detail about Saudi Arabia is not incidental. It's chosen for a reason. This single document, this passport, becomes the absolute cornerstone of the government's argument to deny him bail.
It completely reframes the narrative of his return from Paris.
It shatters it. The defense wants to argue he came back voluntarily, he's not a flight risk. The prosecution's response is to hold up this passport and say he has the tools, the plan, and the destination to vanish forever.
The discovery of that passport on July 6th effectively sealed his fate regarding pretrial detention.
It was the factual pivot. It changed the argument from a standard debate about financial assurances into a much more serious discussion about deception and a concrete escape plan. Everything in the bail hearing flows from the discovery of that passport.
But the passport wasn't all they found. The townhouse was full of other materials.
Right. And this brings us to evidence block 3, what the prosecutors referred to as the stacks.
This is also detailed in the bail memo.
It is. The memo describes the seizure of thousands of sexually suggestive photographs of females.
We need to be very clear here about the distinction between these photos and another famous document.
The Little Black Book.
Exactly. The Jeffrey Epstein Little Black Book, the unredacted version, is in the public record. We have that document. It's essentially a contact directory.
It's a map of his network. It lists names, phone numbers, addresses. It proves connections, associations. It establishes who he knew.
But the photographs found on July 6th are a different category of evidence.
They are. They are not about association. They are about conduct. The Black Book shows who he could call. The photos, according to the prosecution, show what he did. They are direct, physical evidence related to the crimes he was actually charged with in 2019.
Does the bail memo specify who is in these thousands of photographs?
No. In the sections that have been made public, it does not name names. It characterizes the images. It describes them as relevant to the charge of trafficking minors, which strongly implies they depict underage girls or young women.
So we have the prosecution's description of the photos. We don't have the photos themselves in the public file.
That's a critical distinction. We are relying on the sworn statements of officers and the filings of assistant U.S. attorneys as to the content of those images. We can't independently verify them from the public court record.
The raid also yielded a massive amount of electronic data.
Yes. The search inventory, which is referenced in the property receipts and the bail memo, lists numerous hard drives and compact disc CDs seized from the townhouse.
And this creates another gap in the public record.
A very large one. We have the USMS property receipts that prove these items were taken into evidence. So, we know the FBI has them.
We know the containers exist.
We know the containers exist. And we have the bail memo, where prosecutors summarize the contents as containing vast amounts of illicit material, including images of child sexual abuse.
But the full forensic image, the complete data dump from those hard drives, has not been released publicly.
Not even close. We have the summary, not the raw data. So we can document the seizure of the drives. We can document the prosecution's characterization of what's on them. But we, as public observers, cannot audit the full contents.
So on July 6th, Epstein is arrested, his house is raided, and this evidence is seized. The immediate response from his legal team is not to contest the evidence itself.
No. Their first move is to contest the legality of the entire arrest. And this moves us into the next block of evidence, the legal conflict.
They argue that this arrest violates a prior agreement.
They do. They immediately invoke the 2008 non-prosecution agreement, the NPA, from Florida. For this, we have to look at the text of that deal, which is in the record as the Epstein plea deal 2008.
The argument from the defense is essentially double jeopardy.
Yeah.
They claim this case was already settled.
That's the core of their argument. They say, we signed a contract with the federal government in 2008 that granted him and his co-conspirators immunity from all further federal prosecution. They present this as a breach of contract.
A deal is a deal.
That's their position. But the Southern District of New York, the SDNY, had a very different interpretation.
Which they lay out in their indictment, 19 CR 490.
Correct. The SDNY's position was that they were never a party to that Florida agreement. They argued that a deal signed by the U.S. Attorney's Office in Miami could not possibly provide lifetime immunity for crimes committed in New York, which their office was responsible for prosecuting.
It's an argument about jurisdiction and authority within the Department of Justice itself.
Exactly. Can one district sign away the rights of another? The SDNY's answer, demonstrated by their actions on July 6th, was a firm no. They argued that the Florida NPA could bind the Southern District of Florida, but it had no power over the Southern District of New York.
And there's a document that gives us some critical context for why another jurisdiction might feel the need to step in. A document from years earlier.
A very important one. The letter from Michael S. Ryder to Barry E. Krischer. It's dated May 1st, 2006.
So this is 2 years before the NPA was even signed.
Yes. Michael Ryder was the chief of police in Palm Beach. Barry Krischer was the state attorney, the lead prosecutor. And in this letter, Chief Ryder is putting his concerns on the record in writing.
What did it say?
He is incredibly blunt. He writes, and this is a direct quote, "I must renew my prior observation to you that I continue to find your office's treatment of these cases highly unusual."
Highly unusual. That's strong language from a police chief to a prosecutor.
It's extraordinary. He's documenting what he sees as a failure to prosecute. He urges Krischer to examine the unusual course that your office's handling of this matter has taken.
He's creating a paper trail.
A paper trail of institutional failure at the state level. He's saying, my department brought you the evidence and you are not handling it correctly. This letter from 2006 becomes, in hindsight, the foundational justification for why a federal office like the SDNY would later feel compelled to intervene.
They saw the 2008 NPA not as a resolution, but as the culmination of that unusual handling.
Precisely. So the arrest on July 6, 2019 is not just about new charges. It's a direct, formal rejection of the 2008 Florida deal. It's the SDNY stating, through action, that the protection Epstein thought he had bought himself was null and void in their jurisdiction.
It's a clash of two federal districts, played out with an arrest on a New Jersey tarmac.
A legal theory being tested with tactical force. And that legal battle immediately shifted from the tarmac to the courtroom for the bail hearing.
Which brings us to the next evidence block, the bail arguments themselves.
Right. We have the transcript from the detention hearing on July 16, 2019, and the government's bail memo. And they lay out the two competing narratives very clearly.
The defense makes a fairly standard argument for a wealthy defendant.
It's a classic white-collar defense strategy. They argue he has deep ties to the United States, he's a citizen, he has property here.
They offered a massive financial package. They were willing to pledge the 71st Street townhouse, the private jet, basically all his major fixed assets as collateral.
And their central argument was he's not a flight risk because he just proved he isn't. He knew he was under investigation, and he flew back to the U.S. from Paris.
If he intended to flee, he would have stayed in Europe or gone somewhere else.
It's a logical point. On its face, it's a strong argument. He had the opportunity to run, and he didn't take it.
But the government's counterargument was built almost entirely on the physical evidence seized on July 6th.
That's right. They didn't have to argue about hypotheticals. They had exhibits. First and foremost, they presented the fraudulent Austrian passport.
The one from the safe.
The one from the safe. That became Exhibit A. The prosecutor's argument was simple. A man with a professionally made fraudulent passport under an alias, with a listed residence in a non-extradition country, cannot be trusted.
They effectively used the passport to argue that his return from Paris wasn't an act of submission, but perhaps just a stopover.
Or at least that he had a well-prepared Plan B. They also cited his assets, the cash and diamonds as ready funds, and his ownership of private aircraft, referencing the flight logs, as the means of escape.
They also raised the issue of witness intimidation.
They did. The bail memo expresses a serious concern that if he were released, even under house arrest, he would use his immense wealth and influence to intimidate or otherwise tamper with witnesses and victims.
So it's a three-pronged argument from the government. Means opportunity and motive.
But the passport was the anchor. It was the physical proof that this wasn't just a theoretical risk. The transcript shows it was incredibly persuasive to the judge.
And the judge's decision was to deny bail.
Correct. The court ordered him detained pending trial, and that decision was a direct consequence of the evidence seized from the safe on July 6th. Without that passport, it's a very different hearing.
So he is now officially a pretrial detainee. He is remanded to the custody of the U.S. Marshals.
And this is our final block of evidence for today, the institutional processing of inmate Epstein.
For this, we have the U.S. Marshal Service records, a series of bureaucratic forms.
Yes. We have Form USM 312, the personal history of defendant, It's the standard biographical intake: name, date of birth, social security number.
We have Form FD-249, the Arrest and Institution Fingerprint Form.
The fingerprint card. These documents are the machinery of the system. They strip away the wealth and the status. He's no longer a financier. He's a number, an inmate.
There's also a medical form, USM 552.
The Prisoner Medical Records Release Form. This is the start of his entry into the Bureau of Prisons' medical and psychological system, which was housed at the MCC in Manhattan.
And this is where the record gets complicated regarding his placement on suicide watch.
It gets very complicated, and parts of it are heavily redacted. The logs we have show that he was placed on suicide watch shortly after an incident in his cell, but the specific decision-making process, who decided to put him on, and more importantly, who decided to take him off, is not clearly laid out in the publicly released files.
We can see the outcome, but not the deliberation.
That's the gap. We have the log entries that show his movements. He was on watch, then he was moved back to the Special Housing Unit, the SHU, but the memos, the psychological evaluations, the internal discussions that led to those moves are not fully public.
Let's go back one last time to the internal communications on the day of the arrest, the pinpoint database emails.
These are important for understanding the institutional tone. These are emails flying between the Justice Management Division and other components of the DOJ.
And the language is bureaucratic.
Extremely. The subjects are things like Epstein custody update. The content is just the facts. Subject arrived Teterboro. Subject transported to MCC. Custody transfer complete.
There's no hint of anything beyond standard procedure.
Zero. If you're looking for evidence of some high-level conspiracy or panic in these specific emails, you won't find it. You find a bureaucracy functioning as designed. It is processing a high-profile detainee according to protocol. It is routine, procedural, and dry.
So let's try to synthesize all of this. Let's connect the records from July 6th into a coherent timeline.
It's a timeline that really begins years earlier. You have to start in 2006 with Police Chief Ryder's letter. He documents the failure of the state-level prosecution. He puts it on the record.
Then in 2008, you get the non-prosecution agreement in Florida. It's an attempt to formalize that failure, to seal the case and grant sweeping immunity.
And for a decade, that seal holds until July 6th, 2019. That day is the pivot point. The SDNY breaks the seal.
With a synchronized two-pronged operation.
Exactly. The arrest at Teterboro and the raid at 71st Street happen at the same time. It's a single coordinated strike designed for maximum effect and to prevent the loss of evidence.
It marks the formal transition of this case from the context of state-level leniency in Florida to federal enforcement in New York.
And the physical evidence seized that day, particularly the passport and the cash from the safe, was instrumental. It destroyed his chances for bail. That seizure is what led directly to him being remanded at the MCC, where he would ultimately die.
So looking back at that Saturday, the documents prove a meticulously planned federal operation. We have the border crossing record, the arrest form, the synchronized search warrant, the inventory from the safe, and the formal indictment from the SDNY.
The paper trail is clear and consistent across multiple agencies. What remains unproven, what remains a gap in the public record, are the conversations. Specifically, any communication Epstein had with his lawyers or associates on that flight back from Paris. We know the flight happened. We don't know what was said in the air.
Next time, the evidence seized.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.